and they wait until there is another case similar to see exactly how the courts make their decision.
Yes.
So yes, that was the one. Who wants to be next? Why were we gone silent? Christina, you want to do Firestone? She's gone quiet. Christina. She's quiet.
Maybe she can't get her audio on.
Maybe. Yeah. Bar, you want to do press?
Okay, I'll attempt to explain as best as Miss Denise.
Yes.
All right.
I don't know about all that, but thank you.
So I had a few different opinions, and I think I'm going to end up with this one. So the appeal case, I'm just going to start. This was an appeal case, and it was an appeal case further to a judgment from a divorce case. And the judgment decided that the property is owned by the husband or ex-husband. Properties owned by the companies, which were owned by the husband, could not be transferred to the wife. And that was determination was made because there was no legitimate grounds for passing the corporate veil. So I guess Mr. Press did not conceal information, or he had not acted improperly. So my facts, the Press got divorced, and then the wife came back for ancillary relief, I guess, to appeal the first judgment. And the second judgment included rights under the matrimonial cause of case. And
Causes,
then, the matrimonial. And she was able to, which the second judgment, I guess, the appeal judgment, found it okay for the properties to be transferred to the ex-wife.
And what did he say about piercing the corporate veil, the judge?
The judge was saying it, I guess this case was particular about how we look at passing the corporate veil. And it, well, I know Mr. Crest did nothing wrong, so he didn't try to hide his property ownership, but I know there was just reference that we have to be careful how we use passing the corporate veil in court cases. And this was an example of why.
Yeah, because he didn't hide anything.
Right.
That wasn't the whole point of it. But I think because he had structured it in companies, then as far as he was concerned under company law, he knew that she couldn't have access to it.
Oh, so he may have, okay, so that's interesting. So he may have intentionally set it up that way.
Yeah, most people intentionally set it up that way.
Okay.
Yeah,
so that means that the corporate veil could have been Paris then.
What the courts are saying is that they're not going to pierce the corporate veil for that if there is another way in which that person can get a remedy.
Okay. Thank you.
So because he was he was the ultimate beneficial owner of those properties.
Right. Okay.
And she was his wife. I have to find that case for you all.
Okay.
There's another one, not similar, but has to do with properties, a local Bahamian case.
Okay.
Yeah, I have to look that up, see if I can find that. But yeah, the Court of Appeals said the reason for X's failure to cooperate was to protect his properties, which suggested that proper disclosure would have revealed them to be beneficially owned by him.
Right.
And so the properties were held on a resulting trust using trust law for him, which is the truth. If you put the assets within a company and you're applying trust principles, their assets are being held for him.
Okay, but like you said, we didn't have to go to really prove that because she went under the marital court.
Marital Quarters
Marital.
Act. Yeah, there was no
Ah,
need to pierce the corporate veil.
okay.
This was no act that was done by the company or its directors. These companies were holding assets. That's what they were doing. Now, whether or not this is going to be applied here locally, we'll have to see.
So, okay. Company, all right.
So it says in every case in which the issue of piercing the corporate veil arises, the court has to balance the need to uphold the core principle of corporate personality with the need to avoid the principle from being abused.
Okay.
So it's really looking at it, and they look at the piercing of the corporate veil in the past, and some of it they call that it was abuse of the corporate form. All right, who's next?
I can go
Me.
next. Oh,
Go,
you
Christina.
can go. Are you sure?
I'm positive.
Oh,
Okay. Okay, I had Firestone Tire and Rubber Co. Ltd. versus Llewellyn, the
mhm.
inspector of taxes. And I'm gonna try my best, but it was kind of like hard for me to really. I had to read it a couple of times, and then I know there's an issue with like tax, but I don't really know the conclusion as to where they ended up being taxed more. But the issue, it involved three parties, so it was So the issue was it involved three parties, which was Firestone Tire and Rubber Co. Ltd. That was based in Akron. And who's the trademark holder for the Firestone tires? I'm not sure if you all are aware of that company. And then their subsidiary was also the Firestone Tire and Rubber Co. in Brentford, the UK, and they also had distributors. And so what happened was Akron. I'll refer to the company in the US as Akron because that's where it was based. The company in the UK as Brentford, and the distributor, one they mentioned specifically was in Sweden. So Akron had agreements with Sweden that they would be the exclusive provider of tires, and they would distribute the tires and like try to keep a good amount of stock on hand. And they would only buy from the list of approved manufacturers that Akron provided to Sweden. So Brentford, which is the UK company, was one of the providers. So Sweden could have gone to Brentford and Sweden could have gotten tires from Brentford, but the real process was because Sweden and Akron had an agreement, Sweden should go to Akron and Akron would advise Brentford of what order to fulfill. But Sweden, instead, knowing that Brentford is an approved distributor, just went directly to Sweden. Just went directly to Brentford. They didn't involve Akron at all. But Akron is still making payments off every order fulfilled because Brentford only keeps the factory cost of producing the tires and 5% of the sale, and the rest of the money would go to Akron. So the issue was whether it was an issue of agency, whether Brentford was acting as an agent of Akron, even though there was no agreement between the two of them. And it was ruled that Brentford was acting as an agent for Akron, again, even though there was no formal agreement. But it was because Brentford they're manufacturing the tires in the UK, they're fulfilling the orders, they're receiving the funds in the UK, and essentially they're kind of cutting out Akron because the distributors are coming to them directly. So it was ruled that they were acting as an agent to Akron, but I don't know because it was an issue. I think it was the issue of whether like they were being taxed enough, considering that they were acting as an agent to an American company. And I don't know if it was decided that they should have been taxed more or not. That's what I was like a bit unclear of.
I see. Let me see, because in the conclusion, the judge doesn't really speak to the tax itself. All
Right. So I didn't know if
Right.
that was like a main focus of it, but I do know that it was concluded that even though Akron and Brentford are saying that Brentford is not an agent of Akron, and as we discussed in the last class, like companies are separate,
Mhm. Legal
pe-
entity.
yeah, legal entities like people, but because Akron owns 100% of the shares in Brentford, and they're their holding company, the courts found that yes, Brentford is acting as an agent of Akron, even if there's no formal agreement to that.
Mhm. So I guess based on the decision that the court made that they were an agent, then they determined what taxes were due.
Yeah.
Right. So that'd be a different section, a different matter then would come from the tax authority.
Hmm.
If they decided that they were going to pay the taxes that were due
Hmm.
because they were acting as an agent of their parent.
Yes.
And when
And
it
it
comes to
was the
taxes, especially in the US, the
Mhm.
veil is completely and entirely not only pierced, it's obliterated.
Yes,
You
Yeah.
know, so.
because you
Mhm.
saw it even in the Adams versus Kate case.
Right.
If you read it, you would see where in the US they're not interested in whether or not you're gonna hold up that corporate personality. Far as they know, they piercing the veil. Let's go in straight.
Mhm. Mhm.
Yeah.
Yeah. But did you find the full case online?
I think so. I also had like a hard time finding this case.
No,
I don't
I
know if
just
anyone else had that, but I think I did.
okay. Because I have the whole thing and it is very long.
It is, and then again, like I don't know if anyone else had this issue. Like I sat down and read it,
No,
and
quite
like I
read
made
a
like
couple of-
but yeah, like I made
yeah.
little notes. I made a little notes like on the side, and then I still had to like go back and read it again to like, okay, I read it. Now I need to actually like read it to fully understand what exactly was going on.
You see, because remember when the case started, they tell you what the issue is, the problem.
Yes.
It's related to tax, but then
Yeah.
the issue before the court at that point in time is to find out whether the company acted alone or whether it
Right.
was of its parent.
Right.
So then you have to drill down and discuss just that point. But
Yeah.
in order to get an idea of why we going through all of this, the court have to determine what the issue is. Like, why are they bringing this matter before me?
Mm-hmm.
And to just really to determine who's going to pay the tax.
Yeah.
So that was the whole point. I'm trying to see right now at the end, because I can't remember off the top of my head. I see where they
Shame
agree.
on you.
It's too many cases. Oh,
I'm joking.
you heard my watch talking to me and all, so I didn't catch that. Would you like to read it again?
Hey Siri.
Oh Lord, I have to take it off because it's going to keep talking to me. Yeah, it's between Brentford and the Swedish distributor.
Mm-hmm.
Yeah, and the special, I think, trading. So the special commissioners were entitled to their conclusion that Akron was trading in the UK during the years of assessment and that Brentford had constituted themselves their regular agents for the purpose of it.
Yeah.
And said that Missy Brentford seems to be more involved almost of necessity in this whole arrangement.
Mm-hmm.
Because whether or not they had to pay taxes or not, because in the beginning, they settled the taxes that were due
Mm-hmm.
for the respective years. So if they were acting as an agent, that means that they were entitled to pay.
Mm-hmm.
This is, I can't see how many pages. My computer's not telling me the number of pages.
It's like at least 20, like at least 20 pages.
Yeah. So they give you the years, the amount of the assessment, and then the second series for Brentford. So yeah, so the questions before the court was whether Brentford was carrying on trade on his own behalf outside the
behalf
UK,
of-
right, or whether Akron was exercising within the UK a trade selling tires to persons outside the UK, and whether the trade was carried on by Akron through the agency of Brantford.
Mhm.
So it's all for taxation purposes. Yeah, and Akron was the US company.
Mhm.
Mhm. So it's whether the US company or the subsidiary was carrying on the business for tax purposes. So after they would have determined that the company acted as an agent, then the question comes now reverts from company law to tax law.
Okay, to determine like if they should be taxed more.
Yes. And what
Okay.
was tax? So you wouldn't see that in this case.
Okay, because I know they kept referring like at the beginning of, I think it's the appeal, they start telling you like who's supposed to be taxed, like Her Majesty's residents, but there's some instances where non-residents are taxed. I was like,
Right. Tax
am I
law.
supposed, yeah, I was like, am I supposed to know? I didn't know if I was supposed to know who got like
No,
the
you
tax
don't-
were raised from this, but I understood like the agency part of it. But I
Mhm.
didn't know if I was supposed to also know the decision
No.
on the tax. That's why I thought I was missing that part.
No, your decision is whether or not there was an agency or they were standalone, and then the companies overseas were not to be taxed because they were not considered as an agent of the parent.
Mhm.
Yeah. So you got it.
Okay, thank you.
Got it. All right. Who's next?
Me.
All right. Let's go.
Okay, so hopefully I understood what I read.
I'm
Like
sure.
the first two people. I had Meridian Global Funds Management Asia Limited versus Securities Commission. And from reading the notes from the book, it fall under corporate liability under criminal law. So the facts were Meridian was a part of a syndicate bidding to take over NZ Company, Euro National Corp Limited, that's the name of the company. Mr. Koo and Mr. NG working for Meridian bought 49% of Euro shares, but Meridian failed to disclose to the Securities Commission of New Zealand that they had become a substantial security holder over 5% because Koo and NG wanted to hide the transaction from their superiors. The commission imposed fines against Koo, NG, and the Meridian. The company argued it was not liable because it had not known about it. Hearn J held Meridian knew it was a substantial property holder because as employees, the knowledge of Koo and NG was attributable to the company. The NZ Court of Appeal held that Koo's knowledge should be attributable because he was the directing mind of the company. Meridian argued that was only the board, not Koo. From my understanding, I went back to try and let me see where it is. To try and see what directing mind was. So when I read directing mind, it said the individual suspected of being involved in the commission of crime represents the mind and will of the company. So then I went back, and as far as me reading on understanding, the issue in the court was trying to figure out, did Meridian, while trying to take over the company, know that Mr. Koo and NG already owned 49%, hence not disclosing it to the commission? But when I thought about it, I was like, these persons already worked there.
Mhm.
So would they give the company an update if they would have bought this after the fact? But when I also checked for directing mind and will, it seems as if Koo seemed as if he possibly was a director, so he was making decisions based on knowing what he was doing.
Of course.
So he knew that they could have taken it over because he knew that they already owned substantial. So hence why, this is why I'm getting lost now. So well, the company ruled because, I don't know, I feel like I mix up now. But from my understanding, I wouldn't agree with the ruling. However, because basically, once you work for a company, hold on, I read something in the front here. Under the corporate liabilities.
The co-director.
Let me see. I think I read something about, I know him and Angie both work there. I think I saw something about,
Oh, he was an investment manager.
let me see what he was. I know that he was something. Let me see what he was.
Because it was a businessman and it was Mr. Koo.
Yes, Mr. Koo and Mr. Angie, they both work for Meridian. They were
Right.
both employees. I believe I had seen maybe on another article, but on this one on Wikipedia I'm looking at, I don't see where they said, but I know he held some type of decision making. Because he was the director. Well, I think for him to be a director mind of the company, he had to hold some position to make some type of ruling. He had to had some say. If if they rule that he was a director mind and will, he would have had to held some position that allowed him to make some decision.
Okay. So they decided to purchase shares through Meridian.
No, it seems as based on the article, Meridian wanted to take over NZ. But they had two employees who already worked for them who owned together 49%.
Right.
So they own shares into the company that Meridian wants to take over. Now, me reading through the article, it doesn't say if they were hired after, but it seems as if they already worked there. So there is a possibility that Meridian may have already knew that these two persons working there own this amount.
So it says that
even though
they funded the scheme, funded the scheme by using their authority to buy and sell Asian shares. Remember now, Norman was an investment manager. He was a senior investment manager.
Okay.
And then what they did was they contracted on behalf of Meridian.
Okay.
To buy shares in the companies from ENC.
Yes.
You see, so they had knowledge.
Got it.
So they then went and they purchased the shares without authority to do so.
Exactly, because I see where it states that they didn't want to, where the part is. They didn't tell their superiors.
No.
Yeah.
No. And that's where the directing mind and will came, because they had the knowledge. They did it all on their own.
But the company had to suffer. Yeah.
Yeah. But you see how much fun company law is?
No.
Yes. It's whether 4 or 5 companies, each one of them, it's just like dealing with 4 or 5 people.
Yes.
And even like when a person commits a crime, what you go to, what was the intent when the person carried out that crime? And the same thing when it comes to a company, who is the directing mind and will?
Yes, who's making decisions?
Who's those decisions.
Yes.
And in a company structure, you know who that person is. Because you have the shareholders and then you have the board.
Yes.
And the board is responsible for the day-to-day activities of the company, and they delegate certain powers and authority to manage CFO, COO. So
Yeah.
it's the same thing. It's very exciting to see how people try to circumvent the law, hiding behind a company.
Yes, I agree with that for sure.
All right. So no, you did well. And that one wasn't too long.
No, it wasn't long. It was just trying to gather the issue
Yeah.
to try figure out. And some of these cases that I read, other cases, it was so confusing because I was disagreeing with what the court actually ruled. I don't know.
Why?
Because it just sounded sometimes as if the court was like, it sounded right. In some cases, it seemed as if people genuinely didn't know or just didn't get it.
Mm. Well, don't forget now, when they write this down, it wouldn't be script by script.
Okay,
Yeah.
I got
then-
it, but it's
yeah.
a good understanding.
Yeah. And then when you look at it, they also refer to other cases. And so the decision sometimes lean towards the decision made in earlier cases.
Yes, I agree.
All right. No, that was good. So reading cases are really helpful.
It is helpful, but sometimes it's kind of change your mind.
Oh God, no, don't say that. Don't say that. Don't say that. All right. Who next?
It's good though. Thank you.
It's good. Yes. Who's next?
I'll go next. This is Carolyn. Morning, everybody. Sorry I was
It's
maybe a
not-
few minutes late. Can you hear
Good
me?
morning.
Okay, so also trying my best. I undertook Williams versus Natural Life Health Foods Ltd.
Mhm.
In a case that was done in 1998. And the case Williams versus Natural Life Health Foods Limited falls under the tort, company, and contract law.
Uh-huh.
So the lawsuit was based on the principal law of assumption of responsibility. But in order for this order to be upheld and effective, it must be proven that a company director or shareholder had committed some act, either directly or indirectly, and that the claimant had sufficient reliable details to validate his or her claim. The issues of the case, as I read, there were two directors of a company that contacted Natural Life Health Foods Ltd. With a proposal wanting to open a franchise actually a franchise and open a health food store. And they wanted to use the brand Natural Life. So they proposed to pay the company a fixed fee to do so. And the company Natural Life Health Foods, they agreed to the proposal. And so one of their employees, they created a brochure. The employee's name is Mr. Williams. He created this brochure on behalf of Natural Life, containing, financial projections for the franchise as to, what their selling projections would be, their income, their targets, that sort of information. But he just created it, but he didn't really go over it with Mr. Williams, to see if he had any issues. But so Mr. Williams decided, him and his partner, they decided to accept the proposal, and they entered into the company, which unfortunately eventually failed, and all of their investment, all of their money was lost. So after that happened, Mr. Williams decided to sue Natural Life, alleging that the advice that they had given in the proposal to him and his partner was on the basis of negligence. causing the business to fail and for them to lose their monies. However, the matter went to court, and before the matter was completed, the company Natural Life went into liquidation. So as a result, Mr. Williams sought to go after the company's managing director, who was actually the person who produced the proposal, the brochure,
Mhm.
and also another shareholder, because he felt that they were liable in, for as to the reason why their company failed on the investment. So, however, Mr. Mislin, that was the name of the gentleman from Natural Life, he didn't feel that he needed to, he should be held liable because he didn't really carry out any, negotiations with Mr. Williams. So the matter went to court, and the matter was heard. And based on that, an appeal came forth to the High Court and also the Court of Appeal. So the Court of Appeal eventually accepted Mr. Williams' claim. And after, all the back and forth, hearing the case, the judge decided to, I would say, make Natural Life liable to Mr. Williams for their loss in their investment. And it was on the basis of an assumption of responsibility. So the appeal from Mr. Mislin saying that he didn't feel that he was liable was actually upheld. Okay, I lost anybody there? No? Okay.
I'm
No.
listening.
So I'm just trying to do this in my own words, sorry, but
No,
this
that's
is,
fine.
that's as I understood it. So in the final judgment, the judge ruled that Natural Life was liable to Mr. Williams and his partner, and that they were liable for the negligent advice that they gave to the company. And so the respondents, which was Mr. Williams and his partner, they were able to recover damages in the sum of £85. So that is the summary of my case.
Mhm. That was an easy one.
Yeah, that was easy. And then, so it fell under the 3 types of laws, because with tort law, that's the law that actually gives a person relief if they go to court for any
Mhm.
wrongful acts that would have been done to them. And then, of course, it fell under the company law, because the company law governs the rights of any person or any company organization. And then, of course, finally, the contract law, because, there was a contract in the case between, well, it wasn't, I don't know if it was a contract. Well, yes, it was, because Mr. Williams had decided to pay the other company some sort of fee for being able to use their brand. So that was the contract side of the case. So that's why that fell under those 3 types of laws.
And now you see again how company law is just prevalent in, I guess, all business.
Mhm.
deal. No one goes into business in their personal name.
Right.
The risk is too great.
Mhm.
Okay, Shanice, you're last.
Hello, y'all get at me?
Yes.
Yes.
Child, bear with me because my case was very interesting. I hope I was able to understand and come to the right conclusion, because it was, the official ruling was kind of unclear, but if I'm incorrect, I guess Ms. Archie could help me out. So my case was, Antonio Gramsci Shipping Corp versus Recollectos Recollectors Limited and like about 2 other individuals. So the claim was made by Antonio Gramsci Shipping Company Corporation that ABR's Lembergs, I'll address him as Mr. Lembergs from now on, Mr. Lembergs and 5 offshore companies, which make up like the Recollectors Limited and others. They chartered a number of vessels from Gramsci Shipping Corporation, and they chartered them at less than the market rate. And then they subchartered the vessels to other persons for the market rate. And so they were able to make a profit. And Gramsci Shipping Company was suing them because Mr. Lembergs and Recollectors, they kept the profits from Gramsci Shipping Company, and the profits should have been given to Gramsci Shipping Company. And so they were essentially committing fraud. And it's alleged that the profits that they got from subchartering the vessels were supposed to allow Mr. Lembergs and others to purchase shares in the parent company of Antonio Gramsci Shipping Corp. And the parent company was the Latvian Shipping Company. And so Antonio Shipping Company, they wanted the profits back, and they wanted to pierce the corporate veil and actually sue Mr. Lemberg himself along with the offshore companies. But essentially, you know, the offshore companies were owned by Mr. Lemberg, and the agreement was between the offshore company and Antonio Shipping Company. So Mr. Lemberg he never signed anything stating that, you know, he as an individual was entering into an agreement with Antonio Shipping Company. And so that's why Antonio Shipping Company was trying to get the court to pierce the corporate veil so that they could sue Mr. Lemberg individually. And from what I read, hopefully I understood it, apparently the Court of Appeal ruled that the corporate veil could not be pierced because there was not enough evidence that proved that Mr. Lemberg purposely hid behind his companies to conduct the fraudulent activity. So Antonio Shipping Company was unable to sue Mr. Lemberg individually. I hope that was it.
I want the long one.
Pardon?
I said this was another long one.
Yes, it was, and it was very hard. It was very hard to keep up with, honestly, because poor child was very, very long.
I mean, ain't that long, but it was long.
That's all right. Felt too, Shanice. I'm with you.
Yeah, but when you read the little short ones at the very beginning, like the little Macora and Guilford and Jones, I mean, they give you the overall view of company law. But then when people use companies and different structures, it's not as simple as that.
Yeah.
So I always like students to see how people use companies and the matters that go before the court and how it gets really complex.
Very complex.
Yeah, so I know it gets difficult sometimes, but it's easier than just giving you the simple cases. And then when you get in the real world, you say, okay, I did that whole course, but I don't understand a thing. All right, so you think you need some more?
Negative.
Some more what?
Cases to read.
No,
Yes?
no, that was an N-O.
Disagree.
Oh, okay. I was only teasing.
Good.
All right, so let's go to unit 2. You finished unit 1. So let's go to unit 2 when we look at types of companies. Anybody read it?
Yes.
Wonderful. Oh, wonderful.
And I must say, though, that I was surprised that the material provided was not updated to reflect the amendments in the various acts.
In unit 2?
Yeah,
Okay, where? Which ones?
like you may glean from this that my area is corporate administration. But for example, LDCs, the IBC Act was amended, I think in 2013. I think that was the amendment where LDCs are no longer allowed to be operated. They don't even exist in the act.
You're right. I have it
I
as
know.
yeah.
Sorry,
So,
Denise, what did you say? Because you said they're not allowed to be incorporated.
yeah, I can't hear you guys very well either. Can you hear me now?
Yeah,
I can hear you. It was just that your last word broke off. So I don't
Okay,
know what you
yes, no,
said.
LDCs, limited duration companies under the
Yes.
IBC Act. The act was amended, like I said, in 2013 or 2014, and that whole section was repealed. It was deleted. You no longer are able to incorporate an LDC, and yeah, nor are you able to, there is no provision because it was deleted. There's no provision to extend the time of an existing one. It's very, not very well done really, because it leaves nothing to guide existing LDCs. There's no provision, like I said, to guide you as to how to administer them.
Like a lot of amendments that they're making.
Definitely, as well as the seals. The seals are no
Yeah,
longer
the steel
required.
one was
Steel.
something that I
Yeah.
noticed as well.
Yeah, to the point that the registrar will not, the company registry will not, they don't even check for seals because they don't have clarity on that, and due to that amendment.
But didn't the amendment say if?
Oh, yes.
Yeah, I think you
after
can
that-
choose if you want to seal.
Yes, it is optional. However, there are various, I guess, interpretations of that.
Right.
And some existing companies where it is included in their articles that that a seal must be kept. They have interpreted that to meaning they do not need to seal, use a corporate seal anymore. So the registry, the head there, she said they just don't even accept check for seals anymore. If
Oh.
yeah, so yeah, it's very kind of upsetting, the whole situation.
The thing is, until a matter goes before court, we would
Right.
really know what it actually means.
Right.
But a lot of companies that have seals,
Yes.
they're still using it. They still ask for things to be sealed.
Where, you mean the registry?
No.
Oh,
Local
legally, you mean?
business, yeah. They ask for that.
Yes.
document to be
Oh,
sealed.
yes, they do. But if challenged, then the company's articles, they present the articles and it states that they opted not to have a seal, it cannot be enforced.
Oh, right. But in those that have it there already, they want
Yeah.
their seal.
Yeah. So anyway, it was very nice for me to just skip that whole portion on LDCs.
Yes, no, that's fine. But I know they pull out is like what's that part now? The part they amended the IBC Act. I don't know, not the IBC Act, the business
Company?
license. Oh, the
Oh.
Business License Act, where they were saying that if you were in a building
Mm,
where you're renting, but you have a business at the bottom and tenants at the top. I don't know if you recall when they amended the business license, and they were saying that if taxes was not paid on that building by the landlord, then the tenants, the Department of Inland Revenue had the right for the tenants to rent from the
Mm.
tenants to the inland
Oh.
revenue. Yes, they had that. They took that out.
yeah, they have amended the Business License Act and the VAT Act so much that it is almost impossible, including the people at Inland Revenue, it is impossible to even follow. And
Doesn't read well at all.
no, they have to completely prepare a I don't know, a comprehensive, whatever the word is, where they, you know, rewrite the entire act with all the amendments, because it's impossible. And nobody is able, like I said, even at inland revenue, they're unable to follow it. We have to kind of educate them and bring to their attention the amendments. But anyway, I'm going a little off topic, but yeah.
No, but it's the point that you're making. They keep making these amendments. They make them haphazardly, piece,
Yeah.
piece,
Right.
and they end up to be hanging. And when
Right.
that you're not sure whether or not you should mention or act upon these amendments, because after a while it makes no sense.
Absolutely. And even seeking legal opinions, because there is no authority in the Bahamas you can go to with respect to questions on application or administration of companies.
Right.
And even when we sought legal opinions, they inaccurately opined, and we had to point out amendments that they did not even take into consideration. So I think the industry is in a lot of trouble.
Yeah, and then that's because, again, because we don't have a lot of matters going to court.
Perhaps, but yeah, but perhaps. But I mean, you know, it would be the same attorneys who are not following the amendments that would be bringing these matters to court. So therefore, I'm still, I would still question the rulings, you know.
No, but they'll be corrected and they'll be challenged. I think if they were to go to court, they would look for the relevant sections, because guess what? When the next matter comes to court, they will point it out.
Right.
I've seen things in other laws where things would have gone before the courts, a decision would be made, and then you would see another judge come back when that case is referred to, and they'll tell you, no, this should not have gone that way because of this, or that same matter before the Court of Appeal.
Yeah.
Yeah, but without the legislation being challenged, and once you just really going from attorney to attorney getting their opinion.
Yeah, and that's costly, and it shouldn't be like that, considering we are a financial center. We shouldn't have to struggle to administer companies.
Yeah, but that is how it is.
I understand that. I feel that every day.
Yeah, it's really difficult.
Mm-hmm.
It's really difficult, because I know normally you just go to the articles, go to the legislature, and that's about it. That's all you could do.
It is, and in many times, like I said, it is quite unclear. And I was hoping actually to get some clarity here on a few matters.
Well, raise them and then let's see if we can answer.
Sure.
Yeah, but that's what the class is all about.
Well, that's what I'm hoping.
Yeah. So we'll see as we go.
Okay.
All right. So since you're starting, tell us the difference between limited and unlimited liability.
Oh, come on, really?
Yes.
You hit me with that right there. Limited versus unlimited. I didn't really do a lot of focus on that. Limited versus unlimited. I don't know.
But there aren't a lot of companies that have unlimited liability.
Well, correct. So that's why, I kind, when I read these things, I kind of read them and focus on applicability,
Right. But like people who don't work in the area, they can go, they could be saying, but limited liability. So is there anything as unlimited?
Of course.
So you include it in it.
Right.
So it's just so everybody could have a clear understanding. So limited liability means limited by shares.
Right.
So the limitation of the liability refers to the members and not the company itself. So that's another distinction. The liability of the company is always unlimited in the sense that it must discharge its liabilities as long as it has assets to do so. And limitation of liability by shares may occur on formation, which means when it's actually incorporated, where each member contribute to the capital of the company is limited to the nominal value of the shares. that they all have agreed. Now, once the member has paid the shares for his company, his liability is discharged completely, and he cannot be made responsible for making up any deficiencies of the company or any other shareholder. So in the case of a small private company, however, the advantages of limited liability tend to be what they call illusory, since those who give the company a significant amount of credit and bank overdraft facilities will in practice require personal guarantees from its directors and major shareholders. So a company could be limited by guarantee, and that's where there's no share capital. The members have no liability only until or unless the company goes into liquidation. So the members are required to contribute towards the payment of the company's debts and liabilities and the cost of winding up in accordance with the guarantee. The amount guaranteed will be whatever sum they have agreed to. And in some cases, the agreed liability may be substantial, and it depends on the type of company. The guarantee is not an asset of the company, but is more or less a contingent liability of its members, because it's there until it goes into liquidation. Consequently, it cannot be charged by the company as a security, nor can it be increased or reduced by an alteration of the M&A, of the memorandum, or by agreement with the members, or by any procedure to increase or reduce a share capital. So for those who are members at the date of winding up, who can't meet their obligations under the guarantee, or if the debts exceed what they are liable to contribute, then the liquidator may have access to those who are members during the year prior to the commencement of the liquidation, but only in respect of debts and liabilities incurred while they were members. If a company limited by guarantee has a share capital, its members have two liabilities. They may pay the issue price of their shares and must honor their guarantee in the event of the company being liquidated. They have to pay the issue price of their shares, and they must honor their guarantee in the event of the company being liquidated. There is no benefit to the company in having such a dual liability, and in practice, companies limited by guarantee with a share capital were not formed. The device of the guarantee company is only used when there is no share capital to be issued, but the members of the company wish to limit their liability to contribute towards the company's debts and liabilities. Members are not shareholders, and membership will often be acquired by application. And provision is usually made in the articles for a member to resign. So once incorporated as a guarantee company, there's no provision in company legislation for re-registration as a company limited by shares or vice versa. Since companies limited by guarantee have no share capital, they are private companies and not public companies. So there is no restriction on such companies trading. However, this company structure is normally for NGOs or community projects, sporting associations, educational, and charitable purposes. Though the membership in companies limited by guarantee may fluctuate, such companies do enjoy limited liability and separate legal personality. And it allows the ownership of the property and contractual rights and obligations without attracting personal liabilities to its members. So like I just mentioned to Denise, and we were just starting it out, I was saying that there is unlimited companies, and then normally private companies. And the members of those type of companies, the reason why they really don't exist. They're sometimes formed by persons who wish to keep the company's accounts away from the public eyes. And there are advantages in having separate corporate status and perpetual succession, even though these are not accompanied by limited liability. So those type of companies are very rarely incorporated. There are some special features of unlimited companies. An unlimited company may reduce its capital by extinguishing liability on partly paid shares, or even repaying capital to the members by passing a special resolution to that effect. An unlimited company cannot issue redeemable shares. It may, if its articles permit, reduce its capital by buying back the shares of its members, even from out of its capital. An unlimited company enjoys privacy in regard to its financial affairs because it need not deliver copies of its accounts and reports to the registrar, but must prepare audited accounts for its members. The price of privacy is the unlimited liability of its members, and the provision in regard to the annual accounts does not apply if the company concerned is a subsidiary or holding company of a limited company, or under the control of two or more limited companies. So if the sole member or director of a private company dies, and there is no board to approve the transfer of his shares under the terms of the will or on intestacy, the company is in effect paralyzed, being without a board or shareholders. The articles should be altered so as to allow, for example, the company secretary, if one has been appointed, to authorize a transfer, or to allow the personal representative of the deceased member to appoint a director if the company has none. The director could then approve the transfer and the business of the company could proceed. The articles should speak to the time period to refuse a transfer, or if any power is vested in the directors, the time period to exercise after lodging the transfer and after the court can compel the registration of the transfer. And a power of refusal should be in the articles. So I mentioned that before about NGOs, normally by guarantee. You could have a hybrid company with guarantee and shares. And of course, you can have a public company. And a public company are those that are on the stock exchange, whether it's the domestic stock exchange, BISX, or one of the international ones. So a public company, of course, could be limited by guarantee and by shares. And of course, that they have to comply with the Companies Act. So public companies are incorporated under the CAC. And they also have to comply locally with the securities legislation. And in other countries where they're on the stock exchange, they have to comply with the securities legislation in those jurisdictions. So that means that they have a lot of filing requirements and a lot of disclosure. So here, under the Securities Act, they have to file a prospectus, and they have financial reporting, they have proxy requirements, they have material change reporting. And being on the stock exchange, whether it's BISX, the New York Stock Exchange, the Tokyo Stock Exchange, the stock exchange itself has to exercise its regulatory function and make sure that the persons who invest in those companies are being protected. So their role is looking at the prospectuses itself, the distribution, looking at the obligation of the company to disclose information and any other obligation it has in terms of advising the public, the governance of the public issue, how the company is being run on the board of directors, the approval of those, the approval of the shareholders, whether there's been any misconduct by the board or the shareholders, and of course, any reporting on the company itself, negative news. So in addition to those type of companies, you also have a statutory company, and those are companies that are created by statutes. And mainly in the financial sector is the segregated account company, the SAC, and that's normally used in the investment sector. And that's where the company would actually segregate each asset from each other. So in the event that it is sued, it will only sue, it can only sue the assets that are in that one particular SAC, that one segregated account. So a company would incorporate a company and then have it incorporated under the segregated accounts company. So a SAC is just an account containing assets and liabilities, and they are, like I said, legally separated from the assets and liabilities of the company's ordinary account or general account. The companies having segregated accounts are known as segregated account companies. So an account that is registered under the Segregated Account Act, they operate as segregated accounts with statutory divisions between the accounts. And like I said, it allows the assets of that one account to be restricted from the liabilities of another account. So the accounts are self-dependent, and that means that only the assets of a particular account may be applied to the liabilities of an account. The SAC consists of a general account, and that contains the assets and liabilities that are statutorily separate from the assets in the SAC. So any company which is incorporated or registered under the Companies Act or the IBC Act may apply to the registrar to be registered as a SAC. But they'll need the prior written consent of the primary regulator. And it has to be engaged in one of the following businesses to be registered as a SAC: an investment fund, or they could be issuing securities, an insurance business, could be subsidiary of a bank or trust company, not licensed by the central bank, or it could be engaged in any other business with the written consent of their primary regulator. Like Denise said, we skipped that part.
Mhm.
So incorporation of a company under the act, companies,
Sorry, could I just ask something?
go ahead.
One of the benefits supposedly of an unlimited company is privacy, because it's stated that it doesn't have to deliver its annual accounts to the registrar, but a limited company doesn't have to either.
Agreed,
Okay,
yeah. Long
so
as
I
it-
just can't figure out the benefit of an unlimited company.
no, there isn't any. There really, a lot of people don't incorporate them.
No,
I just added it in because I know sometimes students will say, but what if it's unlimited?
I didn't even know you could do that, because I thought that was the whole purpose of incorporating an IBC due to its limited liability. In essence, it's an LLC.
Yes. Yeah,
Okay,
it is an LLC. Just that when you look at the US LLCs, they get really tricky because they structure it
oh
depends
yeah, I
on
don't look at them.
what they're trying to do.
Yeah,
Mhm. And
okay,
they seem to be kind of surprised when they realize we just have an IBC.
yes.
They be trying to do all kind of tricky things and
Mm,
to figure out, okay, what are you trying to do? And that's when they come back and they say, okay, I'll incorporate an LLC in the States first, and then I'll incorporate one here.
right,
Yeah, they find different ways. I don't know how much taxes they're evading when they do these things.
yep, that's what we all have to determine.
Yeah, but then we all have to become tax experts.
Well, you got to limit your liability as directors of a company and assess all that.
Yeah, but that's if you become a director. If you become a
Yeah.
director, I have to figure it out. Why are they going this route? Why are they doing it this way? Because you'll see where they'll incorporate an LLC. They're the sole member, sole director, sole officer, and then they come. They want to incorporate another an IBC here
Right,
as a area of that LLC to hold a piece of property, And you're wondering now, why did you incorporate the LLC in the States? Because that one is doing the same thing. It's just parent of the holder of the asset.
Yeah,
But that's the way in which I guess that's the way in which they were told.
right. I was just gonna say, those were the types of structures that was suggested by, the wealth planners, the wealth
The wealth
advisors. but-
yes.
Mhm.
And that's what they do.
Yeah,
Right. So a CAC company limited by shares, limited by guarantee, or shares and guarantee can be incorporated in the Bahamas under the Companies Act or the IBC Act, and nonprofit again. A Companies Act company must have a registered office in the Bahamas. The company is required to maintain certain of its corporate documents at the registered office. And that includes the M&A, the share register, the minutes and resolutions, and the minutes of the meeting and the resolutions. Must have 2 directors and 2 shareholders. The officers of the company may comprise the president, the secretary, the treasurer. And although there's no statutory requirement for specific officers that a Companies Act company must have. Generally, the secretary or an authorized person under provision of the articles is required to affix the seal to certain statutory documents. And of course, that's bearing in mind if they have one.
Mm. I don't think that amendment was made to the Companies Act, though.
Hold on, let me get my act.
Yeah, that's what I was wondering too when I read it.
No, I don't
'Cause I
think
know
so.
for sure the IBC it's optional.
Yeah, I'm not aware. I mean, there has not been an amendment to the Companies Act with respect to a seal.
Because you have to put the seal on the when you file the M&As, right? Or no?
No, we don't seal those.
Okay, no.
Let me see. I have my CAC in my hand. Yep. Let me look. Which section was that again? I just remember these numbers over my head. The seal is section,
Usually at the end, right? I don't know. I don't
yeah, not too close to the beginning. It's only when you're looking for it, you can't find it, you know.
Yeah, I'm almost positive that the amendment, the Companies Act has not very many amendments,
They don't, because
recently. Yeah.
we don't have a lot of matters that requires to make any changes.
Mm.
Let me see. I mean, they've added in some stuff, but
Mhm.
I thought it was around that number. And because I don't see it, then it probably wasn't done. So it's just the IBC.
Yeah, I mean, I can double check as well and let you know or whatever.
Yeah, I don't see it here. That'll take time to look for that. And I bet you as soon as I clap off, I pick it up, I'll see it.
Yeah.
That's when I'll see it. So I don't think I need to go through the whole process for
No.
incorporation. No, I don't need to do that. Hold on, let me put it on the side. So I know I go find that as soon as I finish. Because that's an automated process. And I don't focus too much on the fees. Because
No.
I have a very suspecting feeling that after they've come back with this new system, fees going up.
They have already proposed that actually, that I had read in the newspaper, it was proposed that definitely company fees and incorporations are all going up.
Hey, hold on, and these people are ready? Take a long time to pay fees.
Yeah,
I don't know how good that's going to be.
no, and no more ring fencing. They can't just raise it for the IBCs and not for the domestic companies. So
Yeah.
I
So
don't know.
I don't know. And you can't price yourself out of the market. When I say out of the market, out of the international market.
But I think our fees are still very low in comparison to the other financial centers, to be honest.
Yeah, but you see, even though our fees are still low, you have to add to that service.
Oh, let's not go there because we could have a whole class on that.
No, but I'm saying the service, you see, they go
Yeah.
hand in-
Absolutely.
because I notice when persons come here, business persons to incorporate IBCs, let's say they do one or two,
Mhm.
ask them for a copy of their org charts. It's just surprising how many companies that they have incorporated recently in the same time frame in other jurisdictions.
Yeah.
You see what I mean? They may do one or two here, but when you look, they have done the ones that are going to carry the bulk of the activity. They're done in BVI or they were done in Cayman, like other places, but here.
Yeah. Yeah, but I mean, I think that is also changing because we had a very rigid, although internationally we are still seen as a tax haven. We've had a rigorous due diligence process, and I think the other jurisdictions are catching up. So there's really nowhere is preferable over another anymore, and a lot of people are realizing that the Bahamas is still a very lucrative, jurisdiction to incorporate companies.
But you do have some persons who wish to incorporate and don't want to provide KYC.
Oh yeah, then they don't get incorporated unless they go to somebody who's willing to overlook that, and whoever would do that now, based upon the fines and everything else, good for them.
Mm-hmm. Yeah. But it's still a lucrative business to be in.
Yes.
Yeah, we'll wait and see how these fees will look like.
Yeah, they're coming.
Oh, it's not good.
No.
It's not good. All right, and I think everybody knows about VAT, so I don't have to do VAT.
No.
What about VAT? We need to know.
No, I mean it depends on what the person is doing. Okay, if they're incorporating a company to hold vacant land based on the value of the land, they have to pay tax. And I think the Department of Inland Revenue is now pursuing all of those outstanding taxes.
Mhm.
Who's purchased land over 7,000.
Oh, I don't know.
Yeah, I think it's over 7,000. I just looked at it yesterday. They're now pursuing because they found out that foreigners have not been paying VAT lands of the time they purchase it. So
I'll tell you this, plenty foreigners are getting, I mean, I'm not against foreigners or foreign investment, but they are getting, I mean, it's catching up now, but they're getting away with a lot of stuff here.
yeah, but that's what I'm saying now. That's why they're trying to collect these funds from them.
I think they should. I mean, we have a client who's an investment fund manager and he pays absolutely zero besides the rent on his building, and wanted, when we advised due to the most recent amendments to the VAT Act that they now had to be a VAT registrant, they were terribly upset and felt that they should still be exempt.
Mm,
But I have a question. How is it that the foreigners aren't paying? Like I guess when they purchase the land, wouldn't it have to be some legal
Oh, I wasn't
representative
necessarily
involved?
referring to land, actually.
Oh.
I was referring to
Okay.
yeah, to VAT and the fact that they had clients that they deemed they were not conducting business within the Bahamas. But due to the amendment, I think it's now from within, whatever
Okay.
the wording is, it now extends to the fact that the service is being initiated in the Bahamas. VAT has to be paid on that service, I think is how it goes.
mhm.
So if in a case of land purchase, so they're not getting away, because I would think like lawyers have to be involved, and then the VAT is somewhere included in purchase or sale.
So that's at the beginning.
Yes,
Okay,
but ongoing.
This
Okay.
issue is ongoing now.
Okay,
Ongoing. That's
that's
the
not
get
good.
close.
Yeah,
Yes.
that's not good. Okay.
Because this is a business. This is a business whereby I see a piece of land. I purchase it, I hold it for 3 years, and then I put it on the market.
Mhm.
Okay, okay.
Right. So
So
in
for that
those
3 years,
years,
you would not have paid, I guess, property tax or
dollar.
anything.
That's right. And so now someone else get it. And they hold it for 3, 4 years. They flipping. Every time they flipping it over, they
Mm.
selling it 3 times the price that the
Wow.
other paid for it.
Yeah,
Yeah.
on top of when they develop it.
Whoa, whoa.
When they develop it, then of course they got taxes because
Yeah.
that's the process. But you're talking
Yeah.
about just holding the land and flipping it over, holding it and flipping it over, not the ones who do development on the land. But
And that's
but
because. Mhm,
go ahead.
And
Go
is that
ahead.
because we're like our regulators aren't regulating it properly, or it just falls down and we only go
I
or
just
check
There
on
are
it?
loopholes.
Okay,
loopholes.
okay.
There's loopholes, and if there are loopholes, people take advantage of those loopholes.
Yeah.
As any good businessman would, I guess,
Yeah.
because
And that-
morality doesn't play in this.
No. So that's a big loophole that they're trying to close.
Yeah.
Mm-hmm. So like Denise was saying, the IBC is a corporate vehicle.
Okay.
And most foreigners come here to incorporate IBCs because that's what they use for their business. Is to me, having an IBC is just like having a stack of cards in your wallet. Each one is a company incorporated for a different purpose. So that's why when you see sometimes they come, they say, I'm incorporating 3 companies, I'm incorporating 5 companies. Depends on what they're going to do. So it could be part of a business, commercial context, or it could be a part of a trust complex, or it could be part of just doing financial planning or wealth preservation. You can use it in any one of those kind of structure.
I have a question too, further to a comment that was made about the due diligence, right?
Uh-huh.
So can anyone just come and open up an IBC, like provide the documents to the registrar? Or does it have to be through
No,
provider? like a
FCSB
okay.
I
Okay.
or law firm that a law
Okay.
firm or
Okay.
That's a-
Or the provider. Okay. And then that's of course who would need the due diligence, the law firm or
Yeah.
the service provider.
Absolutely.
Okay. Okay.
Yeah. Yes.
Thanks.
And they would follow the same due diligence as what you see the banks do.
financial institution they
Mhm.
fall under. We
Yeah.
fall under.
Yeah. IDC. Okay. Thanks.
So an IBC itself, just like a company, just that is just more flexible. So I won't go through the incorporation because it's very simple,
Mm.
an automated process. But just like a company, it can be limited by shares, by guarantee. You can have, it has a memo and arts, just like a company, a CAC company has share capital, of shareholders meeting, it has resolution, it has directors meeting. But the whole purpose of incorporating an IBC is for confidentiality. When you come to places like the Bahamas and Cayman, BVI, Seychelles, Malta, Gibraltar, is all about confidentiality. And the structures are the same in that they all have to have a registered office and a registered agent in that jurisdiction where it is incorporated. And that registered agent has to have certain documents on hand. And those documents include the memo and arts and the register of members and officers
And certificate of incorporation.
and certificate of incorporation.
Mhm.
And annually, they would invoice the clients the fees to pay for the registration fees and for any other services that the corporate service provides to them. So there are benefits of an IBC. They have exemptions from stamp duty, exchange control, depends on what they're purchasing. If it's property, of course, they have to go through exchange control. And if they are foreigner, 2 persons can incorporate an IBC. They can purchase or acquire on their own outstanding. They're not subject to any business license fees. There's no income tax here. Corporate tax may be coming soon. The doctrine of ultra vires doesn't apply. That means that they can incorporate an IBC for whatever purpose, as long as it's a purpose that's legal. Minimal statutory filings and reporting requirements. The assets can be transferred in a trust for the benefit of creditors or shareholders. The capital could be in any currency. And you know that the name could be in words, numbers, symbols. They could be ending with limited, society, non-NOMA, SA, LLC. So it's a lot of benefits. They could pass directors, shareholders resolution by consent in writing. Similar to CAC, meetings could be held electronically. They could have just one director. That director doesn't have to be resident in the Bahamas. They can hold securities. So there's a lot of benefits. The registration form, go ahead.
I was just saying that the introduction, though, of CESRA has put certain limitations on IBCs with respect to if they're engaged in activity. They would have to have directors in the Bahamas. I mean, that's a whole nother situation. But yeah, CESRA has put quite a few limitations on IBCs that are engaged in relevant activity.
But do we have that many to talk about in terms of meeting that threshold in order to be reportable for CESRA?
Well, you know, our company, I don't think would be considered very big. I mean, we have a handful, but they are finding it very difficult to wrap their minds around the fact that they have to set up an office in the Bahamas and have directors meetings here twice a year or 3 times a year, et cetera, to meet the substance reporting requirements when their company, their relevant activity is only intercompany financing, you know.
But
I'll be on, but there are not very many, no.
No.
But I don't think that's across the board.
No, I haven't heard anyone speak. I know the legislation is there.
Oh, it's there. And I mean, that's one of the reasons of our recent EU gray listing or blacklisting or whatever it was because although CESRA, it had been implemented, it had not been followed through. They did not have sufficient reporting capabilities in order to produce information to show that companies were meeting economic substance. And that's no surprise to me whatsoever, because we have companies that are engaged in relevant activities who haven't met substance reporting requirements or substance requirements, and we have heard nothing from it.
Yeah, because I was still trying to see when they sent out the notice last year, like for a CAC company, maybe you could get information, but for IBCs, how would you really know how much money are they making? They don't provide financial reports.
No, they don't, but we have to reach out and they have to complete the relevant form with all the information in order for that to be included in the report that we make on their behalf.
You know,
it's the director's responsibility that CESRA, the responsibility to report on behalf of CESRA lies with the directors. So, and just as the registered agent, we file on their behalf based
Right.
upon a signed form received from them. But yeah,
Mm.
we send that out every year. And, you know, make it very clear to those that are not meeting their substance requirements that they can be liable to very, very large fines and ultimately be struck off the register.
Sounds similar to the loophole for taxes.
Yeah. Yeah, so so Cesar has put a little spoke in the wheel.
Yeah, and they want us to finish those requirements too. Taxation. They're pushing,
Yeah.
Yep, they are.
So I mean, yeah, like you said, corporate taxes are coming.
Yeah, it's coming, but it's getting complicated because the way in which our companies are structured or the way in which we do business with those companies we have incorporated doesn't allow us to provide the kind of information that they're looking for or to even have some semblance of how we're going to tax.
Yeah, I mean, I guess they would obviously they would have to file or produce financial
With-
statements, which they are required to do anyway, you know, accounting records. They have to maintain accounting records.
Yeah, I agree with you.
Well, I mean,
But-
that's by law, and we have to file that declaration.
Even the maintenance of financial records by IBCs, that declaration doesn't come annually.
No, it comes, you have to, there's one, you file one declaration, and if
What?
the registered office changes, then it has to be filed again.
Right. So how do you know? Unless they change a registered agent, you wouldn't know.
Yeah, but they declare that they will maintain in that declaration. That's a one-time declaration where they declare that they will maintain accounting records and they will be available within, I don't know, what is it, 7 days or whatever? If requested by an
But we have-
appropriate body.
Yeah, but we've never tested it.
Oh, we've had inspections, and they have requested financial accounting records for a handful of the companies. Sure did.
Okay. Okay.
And everybody had to scramble.
Oh,
I
those-
have a
I know there had to be a scrambling somewhere because I know that I don't know. I don't think these people do these things.
Yeah,
Okay.
well. Mhm.
okay,
Go
a
ahead.
a question there. Sorry. So the annual declaration for the accounting information is not required annually?
No,
No,
Really? For an IBC?
Yeah.
For an IBC?
no.
no.
Oh,
And it's only required for an IBC. No, I mean, that was the, in the 2013 order. I think it stated that, but it was amended in 2016, and it was not required that it be on an annual basis.
It's a one-time thing.
oh,
Unless the registered office and agent changes, and at
Okay.
that point, a new declaration has to be filed for some reason.
thank you.
Thank you, news to me.
Yeah,
Mhm.
we, because we're just working on, okay, thanks.
You know, and that's where the registry fails. They should say, you know, you guys really don't have to be filing these every year.
Yeah, they're not checking.
Yeah,
No.
that's what we realized. Oh,
And they say that.
wow.
Yeah, they probably say, okay, well, y'all want to keep doing it.
Honestly. So,
But it's-
but they do Securities Commission, during their inspections, they certainly, review accounting records.
yeah,
And where anybody provides directors on these companies, you, definitely are required by law yourself to maintain financial statements.
mm-hmm. Yeah. Yeah, that is also changing like other areas, like other areas in the financial sector.
Mhm.
Yeah, it's changing. So a foreign company carry on business here in the Bahamas if it registers under the Companies Act. The provision doesn't obviate the foreign company being licensed in respect of such business. And to be registered, the foreign company must deposit with the registrar general particulars about the company and a copy of its constitution under the public seal of the country under whose laws it was incorporated.
Mhm.
They pay the requisite fees and filing, and the registrar will issue a certificate of registration and publish a notice of such registration in the Gazette. Upon registration, the issue of any necessary license is applied for. The foreign company may carry on and is undertaken in the Bahamas, and the provision of the act will apply to the foreign company, including the requirement of filing an annual statement listing its shareholders, directors, and officers. And the foreign company has the same capacity as a company under the act itself. And a company incorporated under the act has the capacity and all the legal rights, powers, and privileges of an individual of full capacity, unless those powers and rights and privileges are limited in the M&A or the charter. Then there's the requisite fees for registration. So once registered, a foreign company must maintain a registered office here in the Bahamas, and the address has to be notified to the Registrar General. The name should be exhibited outside the registered office and outside all of its other places of business in the Bahamas. The name must also be given on all commercial and other instruments of the foreign company, and foreign companies should also submit an application to the BIA for NEC clearance if the turnover is within the Bahamas or if they seek to employ more than 2 non-Bahamians. There's a question I had to ask you all in terms of putting the name outside the registered office. Do you all have an electronic board put the names on?
No, we have that old kind, but that's just for domestic companies. We just have a little push. We push the letters in to a board.
Yeah, we have the same thing, push the letters in, but you know something electronic?
On the outside,
But we get it somewhere outside, inside.
it's posted on the outside of our door.
Yeah, but when you're talking about but not hundreds of companies, how do you do that?
Oh, I don't know. We only have a handful of domestic companies, maybe 20. So it's easy to maintain that on the outside of the door. But I mean, we have our information system, internal information system, definitely.
Oh, I mean, in terms of meeting the legislative requirement to have the names.
Yeah, we don't have a lot of them.
Yeah, that's probably why.
But I saw in a law firm, I went into one of those big ones. They had the whole backboard in their reception area was just loads of what I assume were domestic companies, and they were not electronic either.
That's a good business someone can go into.
Yeah, if you want the liability.
No, I mean just putting the names up.
Oh, yeah,
Not that part.
yeah.
What else? Undertaking of the foreign companies to be carried on with a view to obtaining a turnover or receipt of money from that business, then of course you need to get your business license. And depending on whether the turnover from his business is within or outside the Bahamas, the foreign company should also apply to exchange control to be for its designation as being either resident or non-resident. And if you're designated resident by exchange control, of course, you require approval to operate a US dollar account in the Bahamas and to receive a contract of payments in US currency.
Only if it's in excess of $100,000, the US dollar account.
Yeah, not
They lifted that.
that's another area where they've done a lot of amendments and a lot of delegation, and they
Yeah,
have, and it's all done in Word form or PDF, but there's no amendment to legislation itself. So it's more procedural rather than legislative.
yeah. Well, that was definitely legislated, should I say? I shouldn't say definitely, but I forgot what it was called. Removal of, I don't know if it was after the removal of the preferential, whatever. thing, but that occurred a couple of years ago where there is a if a company wants to maintain a US dollar account that's less than $100,000, central bank approval is not required.
Mm. I just don't remember. I just don't remember seeing it refer to legislation.
Perhaps
don't-
not. I don't know what it was based upon, but I can definitely share it the next class if anybody's interested. I don't have it at hand, on hand.
I'm sure they are interested. They're just trying to keep up. So the only thing, just a table. They have just pulled out the sections.
Mm.
Just of reference. So I have a question for you all. You know, on the first day of class, I wasn't feeling well. I want to make up that class on Tuesday or Wednesday of this week so we could stay on schedule.
Oh my
Which-
goodness. You mean
It's-
after 5 o'clock, I guess, eh?
It's on money laundering, so client due diligence.
Mm,
I'm
yeah.
fine with that.
That's fine.
Which day?
Which-
Uh,
What
whichever.
time? What time you talking about? Like 6 to 9?
6:30.
I'll be snoozing.
No, it won't be
Wednesday?
enough. Better.
Any day.
This chapter is on clients due diligence, so it's not that long. It's something that everybody does.
Definitely. That's why I said I'll be snoozing.
Oh,
I'm good. I'm good with either day. So if
Yeah,
anyone
either
has
day.
a preference,
I'm
Wednesday,
good with Wednesday.
Wednesday.
so
Okay,
Wednesday's
Wednesday.
fine for me then.
quite fine.
30 or 7? Which one?
6.
Ooh,
Ooh, maybe
6:30.
7.
6:30.
6:30 fine.
Yeah,
6:30,
6:30.
yeah, that's fine.
Yeah. And because it's on due diligence and you all know the law and know what's required, it shouldn't be that long. So it'd be more discussion and anything else.
Sounds
if-
good.
But if anyone has any question from their day-to-day work, you could bring it.
Okay.
Yeah, related to due diligence. All right. So I'd let Mr. Pratt put us on for Wednesday at 6:30. Okay?
Sure.
All right.
Sure.
So rest of your
Okay.
weekend.
So
And the
you,
court
unit
front-
3 is due diligence, right?
Yeah.
Yeah, okay.
Just a quick
Thank you.
question, please, for clarity. A foreign company is registered under the Companies Act. Foreign company means it's a foreign entity?
Yes.
I'm confused. Okay. And companies with like, I guess a Bahamian registered office will be considered an IBC? That's what you're saying, international, that's what I think I'm confused with. An IBC, international, I guess that word, international business company versus a foreign company.
Two different things.
Yeah. A
Okay.
foreign company is one that exists somewhere else and is already incorporated and they just want to register here, not incorporate here.
Okay, okay.
Yeah.
Okay,
That's it.
understood. Thank you.
All right. Okay, so get out your blankets for the cold front that's supposed to be coming.
Outside
It
feels
did-
so good. I think that I'm in.
They said weak cold front.
Oh, week. Oh, okay. I didn't hear the-
Oh, well, not yet.
So that means it'll be 79 instead of 89.
Oh,
weak.
but you breathe. I don't think the number changed. And it's the same.
No, it's nice. So
It's hot.
yeah, okay, it's hot. I lied.
All right.
Yeah.
Enjoy.
take-
Okay,
care.
thank you. Have a good weekend.
All
Thank
right.
you. Good day.
Okay. All right.
Good day, everyone.
Good
Bye-bye.
day.
Bye.